One of the most frustrating, I think, claims that I get calls on have to do with condominiums and water damage in condominiums. People want to know, hey, there was a leak in my condo, the water went into somebody else's condo, am I responsible? I'll get calls where somebody had an upstairs unit that had water damage leaked into their unit. Why isn't their insurance paying it? What about the association? Do they have to pay for this? All these questions, it's confusing. We're going to try and sort this out, make sense of it. So follow me. Let's do it. My name is Mike Keeler. I'm a licensed public adjuster in the state of Florida. All right, so let's talk about if the water came from your unit. Let's say it spilled over into somebody else's unit. Did it happen kind of out of the blue? Just what I mean by out of the blue, it just happened. You had no idea. You go to work, come back, maybe you get a phone call, your unit's being flooded, you found out there was a pipe under your kitchen sink that broke. That's kind of out of the blue. Or have you had this problem previously? Whether it's from a toilet, maybe a sink, vanity in the bathroom. Have you had this problem before and now it's leaking again? That's an important question because it plays a part in things that we'll talk about later. What exactly happened? Is the problem still present or is it gone? In other words, did you get it fixed? So there could be a variety of things happening. Is it an AC unit that overflowed with water? Was it a pipe? Was it a line? Was it a pipe behind the condo wall that the condo association is responsible for? So all these different questions come into play. Now, let's say that the water came from a unit above you and damaged your unit. What happened from your neighbor's unit? Do you know the story on it? It's important to find this out. Have they been previously warned about a similar issue before by either you, association, previous condo owner? And have you notified the association? These are some of the first things you need to find out. Different states, different laws. Now, we'll cover what generally happens in some of these condominium water damage type claims. But for instance, in Florida here, we've got the Florida Condominium Act. Colorado has the Colorado Common Interest Ownership Act. Now this is a primary law that governs condominium associations in Colorado. New York has Article 9B of the Real Property Act. This is known as a Condominium Act. So this is just some examples of different states and the different laws that they have in place for condos that will probably highlight and share what the association's responsibility is and what the unit owner's responsibility is. So let's take a look at the Florida Condominium Act. This is a Florida statute, 718.018. This is a section where it talks about common elements. Common elements, it's essentially the condominiums association responsibility for this stuff. All right. Probably the most important thing is this part D. The property installations required for the furnishing of utilities and other services to more than one unit or to the common elements. Example, I remember I got a call this week or last week, and somebody had asked me questions regarding a condominium where the pipe was behind the wall. They had no access. Actually, I think it was the ceiling, they told me. They had no access to it. There was some type of leak that not only went into their apartment, but I think a neighbor's apartment. But because it happened in their unit, I guess either the association or a neighboring unit was trying to hold them responsible. So this is a perfect, and I asked them, does this pipe go to other units? More than likely it does. If it's not something, and we'll talk about this, if it's not something in your plain visual sight underneath the kitchen sink. If it's something that you have to work your way to get to, like break open drywall or open up a ceiling or a wall, that is the condominium's, the association's responsibility, at least here in Florida. All right. So again, where it furnishes utilities or other services. Other services would be maybe electrical, utilities, right? Water, that's utility. So this is a key point that nobody talks about. If you have issues with dealing with the association, because you can actually hold each and every person from the association responsible personally. Now this is in Florida, all right? This is one of the sections. An officer, director, or agent shall discharge his or her duties in good faith with the care an ordinary prudent person in position would exercise under similar circumstances and in a manner which he or she reasonably believes to be in the interest of the association. An officer, director, or agent shall be liable for monetary damages if such officer, director, or agent breach or fail to perform his or her duties. Now, why is that important? Because if they know, or if they should have known, that they are responsible for some of the common areas like the ceiling or drywall, which they are, or the subflooring, which they are, unless your bylaws state differently, and they fail to pay you as a unit owner, if you have damage to your walls or ceilings, you can hold them directly responsible. This is their duties. This is their responsibility. And they failed to perform in their duties. This is huge. There's actually a letter that sometimes I send to kind of scare these people a little bit. Okay, so in Florida, the Florida Condominium Act, here it lays out the responsibilities. Underneath Florida Statute 718.11, where it talks about the association, number 11 topic in there, it's about insurance. So let's take a look at it. So they talk about every property insurance policy issued after January 2009 for protecting the condominium must provide primary coverage for, and they talk about the property, common property, okay, alterations or additions, but it must exclude, in other words, it shouldn't include the personal property within a unit, meaning couches, chairs, TVs, or limited common elements, and floor, wall, and ceiling coverings, okay? So that means what you have on the subflooring, your floor, whether it's wood, porcelain, laminate, okay? If you have anything on the wall, paint, wallpaper, anything on the ceiling, that's what they mean, ceiling coverings. So this is the money slide, meaning that, yes, they are not responsible for anything on the floor, on the wall, or on the ceilings. Note this very important area, but they are responsible for the drywall, the ceilings of the drywall, and the subflooring. All right, they're also not responsible for electrical fixtures, appliances, right? So you have your own appliances in a condo. Water heaters, water filters, built-in cabinets, so your kitchen cabinets, countertops. So all this, and it says right here, such property and any insurance thereupon is responsible of the unit owner, is what it says behind my little head here. So all this is your responsibility. This is what, if you have a water damage claim, what your insurance covers. And really the big ticket items on this for the claim are going to be your kitchen cabinets. You draw it right here. Your cabinets, okay? The countertops, and the floors. Where's the floors? Right here. Okay? The drywall and all that stuff, that's relatively cheap. So you have to make a kind of decision based on what the total cost is of the loss, if it's even worth filing a claim. because a lot of times it's mostly just drywall, some paint. You're going to have sometimes some flooring, but if it's not a big condo, it may not be a lot of flooring. All right, let's move on. Give me a thumbs up, like this video, subscribe to the channel if you want to see more videos like this. So I don't want to get too deep and complicated into this, but the bylaws do play a part in determining what the responsibility is of the association and the unit owner. So again, I don't want to get too deep into this because it becomes a legal nightmare. I'm not an attorney. What do the bylaws say about who's responsible for what? Normally, most of the bylaws in Florida, the condos that have been written in the 1970s, obviously newer condos, no, they'll be newer, but they all pretty much say the same, and they talk about the common areas that they're responsible for. But in other states that may not be the case, so you have to check. It may spell out that depending on the association, depending on the condo, depending on what state, depending on the bylaws, that you as a unit owner might be responsible for the drywall. That's I've only seen it a couple times, so I would probably say it's only 10% out of the vast amount of calls I've gotten regarding these water damage claims in condos. So the bylaws are important nonetheless. So generally speaking, this is what I normally see the association in almost all states. Now I'm saying generally, more often than not 100%. The association usually is responsible for the walls, meaning drywall, ceilings, drywall, sheetrock, plaster, subflooring. A lot of times they're responsible for windows, the front door of your condo and or back door, depending how it's laid out, pipes behind walls and ceilings. It never fails. 80% of the time, you can say, hey, I know you guys are responsible for the drywall in my unit, and 80% of the time it never fails. The association will tell you, no, we're not. You have to turn it into your insurance company. If you turn it into your insurance company and you have a law similar to the Florida Condominium Act, your insurance company knows this. The adjusters are going to say, no, we're not paying for it. Your condo association's got to pay for it. And then your condo association's still going to go back to you, say, no, we're not responsible for this. Your insurance company's lying to you. I don't like taking the position of the insurance company, but your insurance company's right on this. The association, at least in Florida and some other states, yes, they are responsible for this stuff. I don't care what they say. So how do you resolve it if they're not willing to pay? Well, you got two choices. You either suck it up if it's not a big loss and you call it a loss to your pocketbook, or if it's not that big, you sue them in small claims court. Because a lot of this your insurance company won't pay for. But what they will pay for, your insurance company, if you file a claim, will cover on the next slide. So your insurance company, generally, more often than not, they're going to cover, again, depending on the bylaws, but let's just say the bylaws are the standard bylaws that I usually see, where common areas are the association's responsibility. Unit owners are responsible for these things. Anything on the walls or ceilings, okay? Ceilings too. Paint, wallpaper, tile, whatever it is. Whatever you have on the wall, that's your responsibility. Baseboards, your responsibility. Cabinets, your responsibility. Both kitchen, bathroom, vanities, whatever. Floors, whether it's wood, porcelain, laminate, your responsibility. The plumbing under the sink, in view, easily accessible, like this picture, probably going to be your responsibility. Negligence. This is a big one that comes up. I get some calls. Please pay attention to this. A lot depends. Let's go back to state by state. As far as negligence, can vary. I can't answer that question if you call. I can't answer if you're at fault or not at fault because it's going to depend on the state. I'm not an attorney, just a public adjuster. So Florida, it's not easy to hold somebody responsible. Example number one. Let's say I own a condo. I come home, there's water all over, it's leaked down to the unit below me. Their ceiling's wiped out. It's wrecked. Now what they have to prove in order for me to be negligent was that, is it a previous issue that I had a leak a month before, 2 months before from the same area and I never fixed it? Or maybe I fixed it and it happened again. Is a previous issue known by the association, neighbors, or the unit owner, but was never fixed? Was it foreseeable? Now let's go back to the top here. If it came from my unit and I'm at quote unquote fault, okay, can I be held negligent? Again, refer back to this. Has there been an issue previously in the same area, same issue as far as maybe it's a kitchen sink, this is a second or third time, the association knows about it, and it wasn't fixed properly. If you tried to fix it though, it'd be hard to establish that you were negligent if you had a plumber come out. Let's put the shoe on the other foot. Let's say that water came from another unit into yours and did some damage to your unit. So your neighbor is technically, quote unquote, at fault. And I'm just using at fault because it came from their unit. I'm not saying they are at fault. Because in Florida, the same standard applies. So for your neighbor, is it an issue that has happened previously that's been known about? It's the same area, same issue. Has it been fixed? Was it fixed? If it wasn't fixed, and this has been occurring over the past couple months, then you probably can hold them negligent. Was it foreseeable? In other words, can you hold them responsible if the pipes were so bad that there had been slow leaking and a little bit of an issue, and they should have foreseen that all this needed to be removed? These are the elements that you have to more than likely prove in Florida to either hold somebody negligent or that they have to prove to hold you negligent. But if you just had a pipe break and there's no real funny stuff and it wasn't like something that had happened before and it's brand new and it happened out of the blue, they're not going to be able to hold you negligent. And the same thing if that happened from one of your neighbors and it happened to damage your unit. You know, if this just happened where a pipe broke or a water line to a refrigerator snapped and there was never any issue like this before and it wasn't foreseeable, you're not going to be able to hold them negligent either. So let's look at the role insurance plays in all this. All right. If your unit caused the damage, I don't want to say caused, but if the water damage came from your unit into somebody else's unit, it's unlikely your insurance company is going to pay for your neighbor's units if they were damaged, or unit, depending how many units were damaged. If a neighbor's unit caused damage to your unit, it's unlikely their insurance will pay for your damages, which means if a neighbor caused damage to your unit, you have to turn it into your insurance company. Okay? And they will pay for everything other than those common areas that we discussed on the previous slide. Okay? They can and should pay. And then they may go after a responsible party, whether that's your neighbor or your neighbor's insurance. If they file a claim with their own insurance, may come after you, even if there's no legal basis. So in other words, even if they come after you and they know that if you get an attorney and fight it, they may not have a legal basis to be able to prove that you were negligent, they can still come after you, your neighbor's insurance company, let's just say, the unit above you, wherever. They can still come after you for the money. Doesn't mean they're going to get it if you hire an attorney and fight them, but they can't come after you. Same thing, your insurance company may go after the neighbor because if they feel there's negligence. Now, they have to prove the negligence, and that's a whole different story, but they can still come after them because a lot of times people may just say, well, I'll pay you a couple thousand. Maybe the insurance company will be happy with that. So all in all, hope you enjoyed this video. As you can see from these claims, there's a lot that goes into it. It's very tricky, condominium water damage type claims. My name is Mike Keeler. I'm a public adjuster, licensed in the state of Florida. If you have questions, need help with a claim, here's my cell phone number, email, website. Thanks for watching this video.